Okay, we're going to get started. Thanks everyone for attending today. I'm interested to hear that there's a lot of delay going on. I'm actually in New York City where it's rainy and a little bit warmer, and heading up to Providence, Rhode Island. So hopefully we don't incur any snowy or icy conditions on the travel northward. So today we're going to go over the Omnibus School Code changes that happened last July, and some of which actually happened in June as well, all in relation to Governor Shapiro's budget. Just going to talk about some generalities that happened with the school code that would apply to all school entities, and then really drill down on the charter school reform, and I put that in quotation marks, for some of the provisions that were included in the charter school reform bill. As many of you have been in the sector for a long time know that many of what we saw in the school code changes with regards to charter school reform were somewhat performative in that they're already part of charter school law or were part of the public school code that applied to charter schools or have been part of the practices of charter schools essentially since the enactment of charter school law. Nevertheless, there are changes and we need to address them. And then also just going to go over some cases of interest that are happening at the national level too, in what we see in charter school litigation throughout the country. I sit on the National Alliance of Public Charter Schools National Litigation Council, and as part of that responsibility is to monitor litigation that's happening throughout the country, again, because what we see is what's happening, in one state is going to be coming to a theater near you. And there are some pretty significant issues that are chugging their way towards SCOTUS. So it's interesting to watch those cases from afar and what the implications may eventually be for the state of Pennsylvania. I did reserve some time at the end to talk about the executive orders that occurred this week, and some executive orders that are percolating as of Wednesday, and various things that are happening in terms of the landscape for education in the United States, for at least for the foreseeable future. So again, if anybody has any questions at that point, we can go over those. So, oops. So again, we're going to go through the legislative update, and then talk about national cases of interest, both at the federal level and some cases that have happened at the state level as well. Again, so in 2023, which should have been sort of the harbinger of doom, if you will, it was the first time since I've been practicing charter school law, which is since 2002, that there were no omnibus school code changes in 2023. But last July, there were significant amount of changes to the charter school law, which do affect some of the more teethy, if you will, toothy type of provisions really were geared towards the cyber charter school movement. As you know, we have a very robust cyber charter school sector here in Pennsylvania, the most robust in the country with 13 operating cyber charter schools in the state of Pennsylvania alone. Most states, if they do have a virtual option, there's usually just a choice of one, as opposed to a choice of 13. So when we talk about choice in Pennsylvania, we're really not kidding. And most of those changes really do affect, particularly the funding provisions, affect cyber charter schools. However, take heed if you're a brick and mortar, because I do think that this is the type of thing that will end up rolling up on the brick and mortar charter schools as well. So it's important for brick and mortars not to feel, kind of a sigh of relief that things aren't going to be changing for them, because some of these changes that have been made only make sense that eventually they're going to fold in the brick and mortars to them as well. In response, however, to the budget that was passed in 2023, the General Assembly did have to make some provisions as of December, in order to make sure that budget funds were flowing. And so there were some significant changes that occurred in December of 2023. Incredibly, we, from a statutory perspective, updated all the terminology in the public school code to reflect the federal law, which has changed eons ago, from mentally retarded to children with physical or intellectual disabilities. The regulations for Pennsylvania Department of Education still use the language mentally retarded. That has not changed in the actual regulations itself, but statutorily, that term has now been updated. For context, the statutory changes from the federal level happened about 25 years ago. So again, we move with lightning speed here, unfortunately, in Pennsylvania. Um, there was a provision in December of 2023 that allowed student teachers to access as substitute teachers. There was a time limit on that, though, that they can only be substitute teachers for 10 days. And again, it provided schools with more flexibility for securing substitute teachers. Again, we all know that there's a teacher shortage, a significant issue with filling the bench, if you will. So this was to give a little bit of a relief valve to schools in order to have at least somebody in front of the classroom. There was essentially a part of the public school code that had maximums that attached to the use of substitute teachers, that you couldn't go over those maximum number of days or hours. They have now been expanded to essentially there are no limitations that an individual may serve as a substitute teacher for a school. However, that is limited to the school years for 2023-24, the 24-25, the school that we're in, and next school year. Again, as a relief valve, if you will, for the issue of the great teacher shortage. That you'll have some flexibility on that. When it remains to be seen if we see in this omnibus school code coming up, which that process is starting as soon as the governor has his budget address in about a couple of weeks in February. Whether we'll see an extension of that because the problem has not really ameliorated itself. So we'll keep an eye on whether they're going to extend that into the 26-27 school year and beyond. But right as of right now, the limitation has been lifted. Again, because of this teacher shortage, the General Assembly then put together this educator pipeline support grant program, and that is under FIA. That is for individuals who are pursuing their teaching certificate, as long as they're enrolled in an improved education preparation program at a college and university here in Pennsylvania, maintain a certain grade point average, are placed as student teachers within the Commonwealth of Pennsylvania, and get all their necessary clearances. Part of that grant relief that they will receive on tuition essentially means they enter into an agreement with the school, either a school entity or not. It can also be used at a private or religious school as well, but they have to commit to teaching for 3 years at that school. There are obviously always extenuating circumstances that are included in that to let folks out of that 3-year agreement. But again, they are extenuating circumstances. It can't be, I just don't like teaching here. So that is another part of the educator pipeline that hopefully will ameliorate some of the issues that we're seeing with the teacher pipeline, but also to attract teachers to work in the hardest hit and hardest to place districts as well. There is a priority for the harder hit areas and harder to fill seats, if you will, in terms of teacher placement. We are investing in school mental health here in Pennsylvania. That has been at the forefront for at least a few years now, and now it has been expanded. Call may be recorded. Welcome to Bank of America. Para servicio en español, marque 9. Hi, if we could mute, please. Please say, "I'm a customer," or if you're calling from a dealership, insurance company, or financial institution, say, "I'm a dealer."
I'm a dealer.
I'm a customer.
And I'm talking about school mental health grants. So for school-based diversion programs, intervention programs, and any educational practices that assist students with persistent and disruptive behavior, which also includes the hiring of staff for those, there are grant dollars that are available for that. Charter schools were eligible to receive up to $70,000. Again, those mental health grants have been extended as of the budget from 2024 as well. And again, there's new training to the Department of Ed, new funding for training that the Department of Ed has received, again, to put together protocols for school-based mental health professionals, and also to provide more certification pathways for school-based mental health professionals as well. There is also a change, for example, in the social worker certification process. That's all related essentially to the school mental health grant. Beginning with the 26-27 school year, there is now a required curricular piece, which is for financial literacy. That is for those of you who operate a high school, that is going to need to be put into place for that's 2 school years from now, and it has to have at least a value of a half a credit. PDE has been tasked with putting together the model curricula for that, and then also we'll put out a certification memo with regards to the certifications necessary to teach the courses in financial literacy. Again, the department is supposed to be reviewing and updating the model curriculum related to personal financial literacy that they already have up. They has to do that by next school year. And also, finally, the State Board of Education will be reviewing the state standards that relate to economics, family, consumer service, and the career education and work pathways, and revise those standards within the Pennsylvania State Academic Standards as well. So that's something to keep a lookout for, particularly for many of you that are just starting out. For those of you who are at high school, you want to make sure you're keeping an eye on PDE to see what those courses are going to look like and what certifications are going to be required, what personnel you're going to need to put into place. And again, that those courses need to be in place by the 26-27 school year. Then July 2024 hit, and then we saw a ton of work being done by the General Assembly. Essentially, that was signed into law by the governor at around July 13th, 14th of 2024. And there are, again, some significant changes that are on the horizon for brick and mortars, but that definitely hit the cybers as well. Again, so July 11th. July 11th, the General Assembly passed and the governor signed pretty much the same day the 2024 budget, remembering that this budget, particularly in the public education sector, was being passed essentially in response to the 2023 decision with regards to the Pennsylvania school funding case. For those of you who may not be aware, there was a case that was actually decided at the Commonwealth Court level that essentially declared Pennsylvania's school funding formula as unconstitutional. In terms of school funding cases, it's the mother of all school funding cases. It's the first time in the history, actually, of the United States that there's been an unconstitutionality standard set for school funding. And it set, obviously, reverberations through the Commonwealth in terms of what the General Assembly was going to do and the governor was going to do in response to that. Particularly because our school funding system is essentially based on real estate. So there are obviously going to be changes in terms of how poorer districts were going to be funded. And so again, with that, they included within that package a number of pieces with regards to the charter school law that were deemed to be, quote, reform. I'll just say, as an advocate for charter schools, there are multiple pieces of the charter school law that do need to be reformed. These might not have been those pieces that needed to be reformed. Again, just as a warning to the brick and mortars, this is not the time to kind of think that, the pressure valve's been released and nothing's coming your way. We assume that many of the changes that were made to the law are going to eventually show up at the brick and mortar doorstep. And as we go on, you'll see that some of these are almost intuitive, that they're going to end up in the brick and mortar category. So in terms of just the global piece, school districts received essentially $225 million, and an increase of basic education funding, and a $100 million increase in special education funding. Those school districts that are underfunded are going to receive, or will be receiving, and are receiving additional dollars through adequacy supplements that are going to come through the Ready to Learn block grant, and in addition to other vehicles that are being developed as well. We did not see passage of the school choice voucher program, which was actually on the docket for last year. Again, wherever you are in the school choice space, we know that school choice vouchers will mean one thing for charters, and that means competition. So it is something that charter schools do keep an eye on. As many of you know, if you've been in the sector for a while, we sort of are the redheaded stepchild, if you will, of the public education space. We are not embraced by our traditional public school brethren, and frankly, the private schools don't like us all that much either. We get lumped in oftentimes with school choice because that is something that is part of our raison d'etre. But on the other hand, we are uneasy bedfellows with the school choice movement. But again, the most important part of all of this is that we're trying to all educate kids in some way, shape, or form. There were increases to the EITC and Opportunity Scholarships program. Again, there was legislation on the table last year that essentially would have gutted those programs completely. And EITC is obviously a very important vehicle, not only for the schools that actually get EITC, but also businesses that use it essentially as a form of tax relief. It again, charters and charter foundations in particular can tap EITC. So this was something that we actually wanted to see preserved, at least, if not better funded. Unfortunately, charter schools still remain unable to access the Public School Facility Improvement Grant Program. This is a shame because, as you also know, if you've been in the movements for some time, or even if you're just starting your school, a big chunk of your dollars that you are receiving are going towards your facility. Our public school brethren can get some relief from that through this grant program. But that actually received $100 million in funding, which is only available to traditional public school districts. Hopefully we'll see some relief on that at some point in some legislative session. But again, we still are unable to tap that particular set of funds. We are able to tap the grant program in order to install solar panels at our school facilities. That program is open to charter schools. The school mental health grants and safety grants have been extended, and we are still remain eligible. And that's an additional $70 million of funding for charter schools alone. There's again another $7 million investment in dual enrollment. Dual enrollment, as you know, is something that's been on the docket for us for quite some time. That was actually passed a couple of years ago that we could actually offer and participate in dual enrollment programs. And now there's some additional funds essentially for those dual enrollment programs at the state level. And the Department of Health, is allowed to issue grants. Again, we are able to participate in that for the provision of free feminine hygiene products for students. Again, that's something that charter schools were also included in. Now, this is a change to the law that actually does apply to everyone, but as you can probably determine, it very much is geared towards the cyber charter movement in particular. And that is the advertising provision changes that occurred in relation to the charter school, to the Omnibus School Code. There has to be a report that's going to be submitted on a yearly basis regarding the use of taxpayer dollars for any paid media advertisements that a public school uses in the Commonwealth. And that there's also a provision that if you do refer to things like tuition, technology, transportation, school expenses, that you have to essentially have a disclaimer that that is being paid for by taxpayer money. We're not the only sort of area that actually requires that. There are multiple pieces of things that happen in terms of public services in the Commonwealth of Pennsylvania that do have the sort of hashtag, if you will, of saying that it is funded by taxpayer dollars. We are now all required to submit a report essentially by August 1st, which coincides with the charter school annual report, by the way, report to the PDE about the total expenditures that are used for paid media advertising. It also requires that you submit information about sponsorships of public events in the 24-25 school year. They have for time immemorial at the General Assembly, particularly opponents of charter schools have tried to institute an absolute ban on advertising, which is very interesting because that would actually be a violation of federal law on multiple levels, not the least of which are McKinney-Vento, special education, Title I. A lot of the stuff that we need to do to reach marginalized families is done through advertising. So and actually part of the CSP grant, in particular, there would be there would be a need essentially to document how you have an outreach, which is also part of the non-binding CSP regulatory guidance. So mercifully, that's gotten across to the legislature that, enactment of an absolute ban on advertising would be in direct conflict with federal law, and they've backed off of that. However, we assume that whatever report comes through, it's going to show that obviously charter schools pay more in advertising than their traditional school brethren, right? Traditional public schools, not really a need for advertising because, if you live in the district, that's where you go. We assume too that the cyber charter schools reports are going to reflect that they are paying quite a bit in advertising. Again, in all candor, there are some cyber charter schools that do more in advertising than others. And again, knowing that these organizations have to reach every single county all over the state of Pennsylvania, as opposed to just a concentrated area of the state, also has to come into play in the analysis. But we expect that PDE will release a report that has quite a bit of fanfare. Again, so school districts, at least we're getting, and this is all related to cyber charter schools, we see at least a relief valve for school districts that will be able to tap a $100 million charter school reimbursement for the students that are enrolled in cyber charter schools that, for the district of residency that's paying for the tuition for that. I've been in this movement for a long time, since 2002, and frankly, I can tell you that the line of demarcation between just not being, not liking us very much to getting absolute vitriol is when the charter school reimbursement line item was removed from the budget during the Corbett administration. Once that occurred, we saw a complete ramp up in terms of attacks on our very existence. So at least that might be a little bit of a release valve for traditional districts to not engage in so much public warfare, if you will, for folks that are just trying to educate kids, just like they are. There is a different special education formula that is now enshrined in law for cyber charter schools. It is a may provision. So a district may select to continue to use the existing special education funding formula that exists in charter school law. It also may essentially choose a different funding formula. That would be based on their actual percentage of special education students. The sort of the genesis of that is that the charter school law is funding special education students at a statewide average. And many school districts, like if it's 18%, many districts are having kids designated as special education as high as 25%. And so it's that delta that's causing the pain point in terms of that funding. I would dare say again that if they have a choice, they're going to pick the one essentially that's going to help them retain as much funding for their own district as opposed to giving it to the cyber charter school. But in terms of that design, essentially, it's allegedly going to save $69 million in cyber charter school tuition. There is a requirement that cyber charter schools have to have a student that's attending on camera once a week, and that is for two purposes. One is for child safety. The other is also for child find. So there is a requirement that, that students have to be on camera every single week for those purposes. It did provide cyber charter schools with flexibility on how they comply with the safety and security training. As you know, Pennsylvania put into place a number of requirements with regards to safety and security training. And it does require that some of that training that you're providing to your staff essentially has to be in person. And for things that make sense, right? active shooter training or sort of drill related things where it would make sense for people to actually have boots on the ground, really are things that needed to be in person. However, for a cyber charter school, there is no school building, there is no real in-person work. So they do have some flexibility on that end for what they now, they can attend most of those courses online. Again, this also has opened up the piece with regards to requiring school districts, intermediate units, local community college, those schools that belong to the Pennsylvania state system of higher education. Those areas and campuses must allow or open up their campuses for cyber charter school use for statewide testing. That is an expense that most traditional public school and charter school do not bear, right? So the amount of money that's spent
Only thing
by
we found
cyber charter schools,
was Rashid's phone, and
um,
he came around.
if we could move, please. Um, the amount of money that a cyber charter school spends on coordinating testing sites, hotel ballrooms, travel costs, personnel, all over the Commonwealth in every single county is pretty significant. And so now they will be able to access these public spaces without having to expend that type of money for required testing. Um, cyber charter school, again, this is one of what I would call a performative one. So cyber charter school is now required by statute to notify the school district of residence that a student has enrolled or withdrawn in a cyber charter school within 10 days. That provision has literally been in place in the BEC since 2002. That was a requirement just not just for cybers, but also for charter schools as well. This is something that's not new, but now it's statutorily, you really, really have to do it as opposing to have to really do it. This is one I think you need as a brick and mortar to keep an eye on, and that is the provision now required to provide gifted education. Since the enactment of charter school laws, charter schools have been exempt from having to provide gifted education. The cyber charter schools are also required to provide gifted education. And I cannot envision a world where two-thirds of of the public school pantheon, if you will, is required to provide gifted education, and they're not going to turn around and say, Bricks, you're also going to have to do this as well. Again, many, many, many schools, even the cyber charter movement, many of those schools were already providing gifted education or gifted alternatives for families. There are many charter schools within the state that are providing gifted education. It's just that, again, it comes with a cost. There is no funding for gifted education unless a student is also declared to also be needing an IEP under the IDEA, but there's no additional funding for gifted education. It does come with compliance measures that you need to fill. And then finally, it also has insurance requirements. Again, you can be sued for not providing or not complying with the gifted regulations. So again, these are more liability exposures for you. But again, be prepared that this is something that's going to be coming to a theater near you. Cyber charter schools are now required to employ an attendance officer or a truancy or a home school visitor. Again, it's all part of the provisions with regards to truancy that Pennsylvania has invested a great deal of time, energy, and love on. However, the one thing to note is that these attendance officers, the provisions that attach to attendance officers and home visitors for school districts that now apply to cyber charter schools means that these folks have full police power. They are allowed to arrest people without warrant. They're allowed to apprehend and arrest children who fail to attend school. They have the ability to go into businesses and demand records, again, not with a warrant, and may inspect and compel records so that they can review to make sure that they don't have anybody, again, that's working there underage or working there in lieu of going to school. So these are quite a number of responsibilities that are now being thrust upon the cyber charter schools. And again, don't see a world where that's not going to end up happening at the brick level too. The thing though is that this was something that was passed in July, and cyber charters were expected to have that up and running by the beginning of last school year. So that's been interesting to watch as it as essentially goes into play. But again, know that these particular individuals have a significant amount of more power than, sort of your family coordinators that are really trying to get your kids to come into school. So again, it's going to require a lot of training. It's going to really require, a number of people that you're going to have to employ. So again, comes with a price tag. Keep an eye out that this may be coming your way. Cyber charter schools are also now required to send to PDE reports of their expenditures in terms of special education students in what looks very much like the tiered special education funding that is already existing for district schools. They have to report, essentially those kids that are under $5,000, between 5 and 25, 25 and 50, 50, 75, and then over 75. We assume that this is again, the harbinger of doom, if you will, for tiered funding that could come our way as well. But again, right now, cyber charter schools do not have tiered special education funding, and neither do brick and mortars. But we see this, at least this report being put into play. Again, I wouldn't be surprised if this is something that they're going to follow up with an additional report for charter schools to submit as well. It does require that cyber charter schools must use the educator effectiveness rating tool. Again, that is something that we've been exempted from the public school code. And again, would anticipate that we see that this is actually going to come to the brick and mortar world as well. Many brick and mortar charter schools are already using this tool. I don't know how much of a heavy lift it would be to shift to that, but again, particularly for schools that have a very specific curriculum or a very specific way of evaluating teachers that relates to the mission and vision of their charter school, this may be a problem. But again, we're keeping an eye on this as well. Cyber charter schools are now required to have a written plan that's approved by the board that really talks about the development and implementation of a sequential program for guidance services that starts in kindergarten and goes to 12th grade. And that plan must include the provision of guidance of services to area vocational and technical schools, which is kind of funny because charter schools are not permitted to use area technical vocational and technical schools. So whether that's a harbinger of something that we might be able to tap into that system, I don't know, or whether this is something where, if a kid wants to essentially go in that route, that they're going to be required to send that kid to the vocational school rather than the cyber school. I don't really know how they're postulating that, but this is something that they also are required to do. So charter schools generally, and this would obviously also affect the brick and mortar world as well, as school districts are now required to submit the PDE 363 by a date certain. That date certain is in August. However, and again, for those of you who are in certain districts, they do their PDE 363. It's all fine. Philadelphia, for example, even though they can be a real, pain in the butt to deal with, in terms of chartering, is usually very good when it comes to their finances. They do their essentially their PDE 363 on time. They communicate with their charters, before the end of essentially budget season, what their rates are going to be. They're a fairly good partner when it comes to budgeting on that score. There are certain districts that don't fill out their PDE 363, which leaves the charter school essentially guessing in terms of what the rates are going to be. And they may get around to doing it sometime in February when you're already halfway into the school year. Now you have to revise your budget. You may have to pay monies back. It creates sort of a real area of instability for funding. Unfortunately, when they put this together, there is no penalty for non-compliance, right? We have for years asked for the legislature to include a penalty. There are penalties, for example, for not filling out or submitting timely your AFR. There are fines that attach for certain reports that aren't put in time. And something like this really should be something where it has a little bit of teeth to it. The legislature chose not to do that. Again, something that we need to follow. They added definitions to the charter school law for things like what is a charter school administrator, what is a charter school entity, what is a charter school foundation. They've also included language with regards to an education managed service provider, which is very overbroad and kind of brings in a whole bunch of people that don't necessarily mean what they think they mean. Frankly, education management service providers has been part of the reform bill for quite some time and really was to be directed at charter management organizations or those organizations that essentially do a significant amount of work within the school, almost akin to running it in many respects. But it's a very broad definition, and it can include things like, for example, if any of you are aware of Charter Choices or Vertex Now, or any of the business management service providers now fall under this definition, which means that your board needs to do a little bit more with regards to the role that they play. But it does mean things like somebody who's doing the school design provider, your business manager, that provides instructional, curricular, educational design, administrative business services, comprehensive management, and the like. So that they're all part and parcel of that education management service provider umbrella. In addition, there are multiple pieces, again, that were part of the charter school law already, or were part of another provision of a statutory framework that now really, really applies to charter schools. And, frankly, are performative. It allowed for the folks that essentially sit on the other side of the table from us, who are anti-charter in many respects, to walk around saying, see, now we're making charter schools more transparent. We are making charter schools be more accountable. And we fixed all the things, which again creates the impression in the mind of the public that's ignorant to what the statutory framework for charter school law is that somehow we weren't doing all of this before. So again, it requires that your board members and your related entity partners have to fill out a statement of financial interest. Again, that's part of the charter school law. It's already been in there. It's in another provision of the charter school law. It's also part of the Public Officials Employees Ethics Act. There are Ethics Act opinions with regards to that a charter school board of trustee member is a public official and must fill out a SOFI. So this is not news. It's part of every single charter that essentially that you sign in order to operate in the Commonwealth. There are CAB opinions directed towards charter non-renewals based on the statements of financial interest and the lack thereof that are circa 10, 15, 20 years ago. So again, this is nothing new in the ether for charter schools, again, but there is the public perception that somehow we weren't doing it before. Again, we must comply with the Public Officials and Employees Ethics Act. Again, already part of the provisions of the charter school law in multiple areas. Now it's in another section just to make sure that we all know that we must comply with it. Again, under the definitions of the Public Officials and Ethics Act, we actually fall within the parameters of that. Again, it's a performative thing. We also have our board members must take an oath of office. We've always had to take the oath of office. If you look in what's called the enumerated provisions, that's under 1732 in the charter school law, it lists the things that we must comply with. Everything else that's not listed there are the things we don't need to comply with. And the things that we don't need to comply with, and you'll hear in ether, it's the wild, wild west, and we don't have to follow a lot of the law. The things that we're exempted from are things that make sense. We are not a taxing authority, right? So all of the things that relate to taxing authority we are exempted from. We don't have superintendents. So all of the superintendency provisions we are exempted from. We don't elect our board members. So all of the provisions that relate to elections of board members and how they're seated, we're exempted from. But in terms of student safety, student attendance, those types of things, we are not exempted from those. And we have never been exempted from the oath of office, which means when your board member is being seated, they are required to take an oath. It's now in the charter school law just to remind us that it has to be done. There are provisions that have been passed that will require you to amend your bylaws. A board of trustees now must have a minimum of 5 board members. So you can't have that 3 to 5. You have to have a minimum of 5. So to the extent that your bylaws address, a maximum minimum, it has to say at least a minimum of 5, and they have to be non-related voting board members. Now, there is a requirement that one of your board members must be a parent of a child that is currently enrolled in your school. Many charter schools already have a parent on the board. The twist here is that if the student becomes disenrolled during the school year, they immediately become ineligible to sit as the parent board member. They may choose to stay on as a community member, but you would need to replace them with a student that is currently enrolled, as opposed to a parent that is sitting on your board that his student has moved on and graduated. And there are many instances of that because the parent is invested, or a parent may be a community member, but they still are in touch with a lot of the parent voice. But that person would need to be a community member and not your parent member. And so, that's something that's going to require a bylaw change. I can tell you that the School District of Philadelphia is already making sure that they're looking for those bylaw changes, or review, even in new charter applications, or reviewing them specifically for these changes. So again, going through the renewal process, you're probably going to see that type of thing happen. You have to establish an audit committee. Again, this is something that many charter schools already had in place within their committee structure on their boards, but now every charter school is going to be required to have an audit committee. Again, there is no requirements or any guidance as to what the composition of that committee should look like. Generally, I've been advising clients that we should look to Sarbanes-Oxley with regards to the formation of an audit committee, only because we have no other guidance coming out of the legislature or even PDE or anywhere else in terms of what that audit committee needs to look like. Again, it's to ensure that your audit actually gets done, but it does have additional responsibilities, many of which are already part of your independent audit process. But there are some additions that, really kind of made us take a little bit of pause as to whether your actual independent auditor would even be able to do those. So this is an ongoing conversation, if you will. Your board treasurer should not be part of your audit committee. The treasurer is the one that's responsible for the school accounts. That's per statute. That's also in, is part of your bylaws. Essentially, that's what the school treasurer is responsible for. And so that the independent audit would essentially be reviewing that role, and the oversight of essentially the finances, so that the board treasurer really shouldn't be on your finance committee. The problem is that, again, it's hard enough to get board members as it is. There really should be people on an audit committee that have financial knowledge, and that's going to be tough if you're excluding your treasurer. So again, to a certain extent, that's the difficulty of when we put together these statutory frameworks without actually talking to people in real life that have to actually implement these things or get feedback on some of these things. So it's going to be an evolving thing, but that has to be in place now. That actually went effective at the beginning of the school year. Again, your audit must be done by a qualified independent certified auditor, a certified public accountant. Again, anybody that's using any of the big accounting firms, that's already been in play. Remembering too, as a charter school, you have a duality of role. You are all a public entity, and you are also a nonprofit. So every nonprofit on the planet essentially goes through an independent audit every single year. This is nothing that, this is not earth-shattering in any shape or form. We've all been doing audits. We have to submit them every year to PDE and submit them to your authorizer in many instances. This is nothing new. But again, they want to make sure that the auditor is actually doing it under generally accepted audit standards and under the governmental accounting standards, which is GASB. Again, there is one charter school in the entire Commonwealth that was not using GASB. And so, of course, every single time one thing happens, we have to all essentially suffer for it. But so now it's enshrined that you must use Gadsby in terms of your auditing structure. And certain things that also must be included in that audit is an enrollment test to verify the accuracy of your student enrollment. And you're reporting to the Commonwealth a full review of the expense reimbursements for our board members and administrators, review of your internal controls, review of your annual tax and state filings, review of the charter school's financial statements with its any foundation that it has as related entity or support organization, a review of the selection and acceptance process for your contracts that are publicly bid. Remember that you are not required to publicly bid every single contract under the sun. Like many of our public school brethren, you are responsible for doing that or mandated to do that for construction, maintenance, repair on your school building. So that would be part and parcel of what they're auditing. And then again, a review of all of your policies and procedures with regards to your internal controls, your code of ethics, conflicts of interest that happen, whistleblowers, parent complaints, compliance with the Sunshine Act, et cetera, et cetera, et cetera. And certain of these are going to be outside the ken of, essentially a certified public accountant. So it's going to be interesting to see what happens. We do note, however, that sort of the big five accounting firms are now entering into the law biz with establishments of their own law firms, if you will, that are related to the accounting firms. So it may be that that we would be able to tap some of that legal expertise for some of these things that really are outside an accountant's ken. But again, this is something to keep an eye on. Again, these are things that I know at least the school district of Philadelphia is specifically looking for when they're doing a review of schools under renewal and also for schools that are applying to become new charter schools. So if, just know that that's something that your authorizer is likely going to start picking up on and making sure that you have that in terms of your audits. The changes in the school code also allow a local board member from the school district to sit on a charter board. That it can't be your authorizer. That would be insane. But now a school board member can sit on a charter school board. Whether that would actually happen, I don't know. It seems to me to be somewhat of a conflict of interest, particularly when we see the type of rhetoric that comes out of the Pennsylvania School Boards Association. My concern is that when we see conditional approvals or renewals of charters or even conditional approvals for a new charter to open, we often see conditions being placed by an authorizer school district that are well outside the charter school law. And it's not without the realm of possibility that a authorizer would say that you would need to have a traditional public school board member on your board. So we're keeping an eye on that. Again, if they come onto a charter school board, they would be under the fiduciary duties of a charter school board member. So the notion that is essentially they would try to turn you inside out or do something that would harm the charter school would be well outside of the scope of their fiduciary duty and would open them up to personal exposure. So at least we would have that sort of be able to rein in any malfeasance, if you will, by somebody coming onto the board that's, not exactly a charter fan. Again, this is an odd addition, which makes when I see odd additions to law, it makes me think that they have more nefarious purposes because I am that person with the tinfoil hat that's sitting over in the corner. So, just something to keep an eye on, but know that there are, public school board members that are now allowed to sit in charter schools. So it'll be interesting to see how many actually get, take up on that offer. And this is also something that came into the charter school law. Again, this has not really appeared in any other iteration of the charter reform bills that have been floating around in the legislature for time immemorial. But now every single charter school board member must be a resident of the Commonwealth of Pennsylvania. That's never been a requirement before. Sort of the scuttlebutt on that is that they wanted to ensure that charter board members would be subject to the Public Officials Ethics Act, and there was a concern that the residency requirement would somehow complicate that. As a lawyer, I don't really see that. If you sit on a board and you're responsible for compliance under that act, your residency has nothing to do with it. Um, the that is a complicating factor for a bunch of charter schools. There are many charter schools that have folks that live in other states that are sitting on their boards for a slew of reasons. And this is particularly true for the goalposts of Pennsylvania. So Philadelphia in particular has a number of board members that live in New Jersey, and work in the city of Philadelphia. We also see on the flank, essentially in Pittsburgh, in the same area where folks are living in West Virginia and Ohio because they flank the state. Um, there is a school of thought that, taking essentially all your board members off who may or may not, who may live in other states, would essentially create a due process problem because they already have been seated and sworn in, so that you would allow them to essentially get through their term and then make sure to replace them with a Commonwealth resident. It is somewhat confounding. There are, I always give the example, one of the folks that actually works in the Graduate School of Education at Penn sits on a client of mine's school board. Now, that's somebody that you would want on your board, right? That's, that has an absolute dedication to the city of Philadelphia, has an absolute, complete understanding of academia in relation to education. And because that person lives in New Jersey now, they no longer can sit on a charter board in the city of Philadelphia for a school that's close to where Penn is. There are multiple schools that have folks sitting from, I have a client that has somebody from Princeton that's sitting on their board, or have a specialized curriculum that has, somebody from a national organization related to that curriculum sitting on the board. Um, Again, not necessarily, having all traditional Pennsylvania residents does not necessarily a good school make, but unfortunately, this is now a requirement. Again, something that your authorizer is going to look for. And so we're navigating that as well. But again, having to have at least 5 members on your board also may be creating issues for you and sort of taking off those non-residents. So again, talk to your solicitor on how to address that as you go forward. But know too that that's something that districts are going to look at during your renewal process as well. This is something that's been percolating for quite some time. Uh, a little bit of background on this. There at one point, again, when a bad thing happens in Pennsylvania, our General Assembly it essentially makes everyone in an entire sector suffer for it. So, as many of you know, that there was some controversy with regards to a charter school administrator that was collecting full salaries from multiple schools that she was working at. This actually involved two administrators out of the city of Philadelphia. So of course, because these two people did this, then everybody they put this rule into place, but constructed it in such a way that it made it a little complicated for particularly for charter networks to actually operate as a network. So those were called the Brown-Gardner additions that happened in 2008. And it complicated things for, if you have more than one school in two different buildings, particularly because districts are really reticent about giving amendments. And in fact, in many instances, just will refuse to allow you to amend because that means more students or more grades, and again, in direct competition and financial impact to them. So the only way that folks could open up more schools under their model was to apply for a second charter or a third charter. And so when you see instances of like schools like Propel or KIPP or Belmont or whatever those schools may be, the complicating factor became because that actual provision said that you could not, as a charter school administrator, you could not collect salary for more than one charter school. So if you're in a network, the best way to handle that would be to have each school in the network essentially contribute to the salary, which would run afoul of the June Brown, Brian Gardner rule. So the provision has now changed. And I'm not saying this is hilarious, but it's hilarious because all of these networks or organizations with more than one charter in their group essentially have moved and put into play corporate structures that allow for their network to operate as a network. So I don't know how many people are actually going to avail themselves of this rule. But it allows a charter school administrator essentially to work for more than one charter school entity or an educational management service provider upon, essentially the board approving it and providing a sworn statement to the board, essentially laying out, exactly detailing the type of work they were going to do and what the projected number of hours, the rates of compensation, and the project duration. Again, I don't know how many charter school administrators are actually going to take them up on, on this offer. Knowing charter school administrators, that are working in charter schools, they're essentially in many instances are the chief cook and bottle washer. So they're running a school, they're, helping to clean the thing, they're out in car line. I don't know how many actually have enough time to actually work for a second school, but here we are. So know that this is a provision. This is actually, something that's been in the reform bill for quite some time. It just got across the finish line now. Again, I don't know how much of a need there was. Some additional school code changes that really are from the general perspective. This one's going to apply to everybody, all school entities, including non-public and religious schools as well. You are now required to have a moment of silence on the anniversary of September 11th, and that it has to be during instructional hours. PDE is required to put together a model curriculum for schools that they can tap. There is no requirement that you actually have to implement this curriculum, but PDE has to make it available. And there are certain things that are required in terms of what that curriculum looks like. Again, it's age appropriate as well. So, what you're going to do in an elementary setting is going to be different than what you would do at the high school, but it must include the historical context of terrorism. It must include, what essentially happened on that particular day, the World Trade Center, the Pentagon, and US Flight 93 that actually crashed here in Pennsylvania, the American recovery and the response to those attacks, and then the global challenges and consequences in the post-September 11th world. So all of that must be part of this model curriculum. They're supposed to make it available on their website. It's actually due in June of this year that they're supposed to get that work completed. But again, you are not responsible or mandated to use that curriculum or even institute, this type of teaching in your school. You are required to do the moment of silence. But should your school so choose, the model curriculum would be available for you to use in your school. There also is a change to the qualifications for a certified public school teacher that are now been amended to include authorized to work in the United States. Again, in response to the teacher shortage, many schools are actually tapping the international market through the HB1 and multiple versions of the HB section of the immigration law to bring in teachers from other countries, essentially to fill the gap, in the teacher shortage. So now there's an inclusion of authorized to work in the United States. Again, as an entity, there would need to be work on the entity's end to ensure that a teacher that's coming in from a foreign country has the HB clearance to be here, and also that they have a work authorization as well. Know that that's going to be part of what we see from the Department of Labor coming forward in I-9 reviews. That we are going to see some significant work in that area. So make sure that paperwork is up to date and valid. Act 82 also has been amended to extend the protections for military personnel that are already existed to extend to the National Guard or to the Reserve, which include things like if somebody is transferred here to be on a military establishment here in Pennsylvania, that they have automatic residency, and that they are permitted to enroll in the public schools of this state, and they have all the protections of a student in the state of Pennsylvania when they're both active duty and National Guard or Reserve. With that, I'm just going to talk to you about some legal updates at the national level. just to talk to you about some cases that have been percolating, some of which have been percolating for some time, some of which are of recent vintage. Um, there is a series of desegregation cases that exist all over the nation. The mother of all those is actually happened in Minnesota, which many of you know. Minnesota was the first state in the union that actually passed the charter school law. It came under attack in terms of being alleged to be part of the segregation system and unequal education in the state of Minnesota circa 2015. This case has gone up and down and back and forth up to the Minnesota Supreme Court at least twice. Um, the Minnesota Supreme Court decided in 2023 that essentially that the racial imbalances in the Minneapolis and St. Paul school districts do not necessarily violate the Minnesota Constitution. And so essentially what the baseline of the complaint was essentially because charter schools in particular in Minnesota there are some that are ethnically based or have certain curricula. For example, there is a charter school in Minnesota that is geared towards the Hmong community, and 100% of the kids that go there are of the Hmong population. The charter schools are essentially engaged in helping to resegregate the school system. They do not, that our opponents in this particular case do not discuss in terms of school choice, that parents are choosing to send their children to school there. And they're also not talking about sort of the cultural affirmation pieces that come along with that choice as well. Um, the plaintiffs in this particular case do not have to prove at trial that the state intended to create segregated schools. They just have to show that there's racial imbalances, but they have to show that those racial imbalances are a substantial factor in children getting a inadequate education. And that's the part that's going to be the heavy lift on the plaintiff side because these schools are outperforming the local traditional public school districts. Plaintiffs throughout this case, it's been pending now for 10 years, have not really ever been able to prove that the racial isolation per se results in poor academic outcomes. Again, there is value in diverse schools that are driven by moral and cultural reasons that have nothing to do with what the plaintiffs are proposing here. It has been opposed by the state of Minnesota, and also charter schools had to intervene into this case to ensure that our voice was being heard in terms of the types of education that is being provided by Minnesota charter schools, and to ensure that the sort of the threat of what they are essentially saying about charter schools was not going to get across the finish line. Was supposed to go to trial in January of 2025. That has now been pushed back to 2026. There is multiple areas of mediation that have been going on, but again, this is something that we see on the horizon. Similar case that happened in New Jersey, and is actually the charter schools did the same thing and intervened in that case and managed to be able to get out on a partial motion for summary judgment with a very similar type of structure. So we keep an eye on these types of cases, and they're popping up, throughout the country. But we had one as close to home as New Jersey. There is a series of unconstitutionality cases which really focus on charter school laws being enacted of recent vintage. Montana is the most recent entree into the charter school world, having passed their charter school law in 2023. West Virginia, the 2019. Kentucky actually has had a charter school law for quite some time. It just has never been funded. So again, West Virginia passed their charter school law in 2019. Again, they have a statewide authorizer, which is different than the structure that we have as brick and mortars here in Pennsylvania, where we're authorized by local school districts. But they had a statewide authorizer, and that's where the constitutional challenge came to pass. Again, there was a preliminary injunction at the trial court level that essentially stopped charter schools from moving forward with opening. it was heard in last year in June on June 8th, and the West Virginia Supreme Court actually reversed the injunctions on procedural grounds because they actually had not included the actual commission itself as a party. So it got reversed on procedural grounds. They amended the complaint, and we're watching it again wind its way through the courts now, but there is a constitutional challenge. In the meantime, charter schools have started to, to move forward and open in the state of West Virginia, but we know that there is a little bit of shaky sand underneath of that. Again, challenge in Kentucky. Again, they've had a charter school law on the books for quite some time. They just have a system under their constitution where unless the General Assembly there actually decides to fund it through their budget, then no charter schools essentially can open. And so the General Assembly actually passed a portion of their budget in 2022 to fund actual charter schools to open out of the state appropriations. And there was a challenge filed right away. That's Council for Better Education versus Glass. They had oral argument in June of 2023. Frankly, the judge was very skeptical about charter schools at the hearing, didn't make us feel all that warm and fuzzy. And at the end of 2023, he ruled that the use of tax dollars to support charter schools violated the Kentucky State Constitution. The General Assembly, in response to that, actually then decided to amend the Constitution, and then had, of course, that has to be put to the public to vote on. And on November 6th of this of 2024, the Kentucky voters essentially defeated that amendment to the Constitution. It was that charter school funding was actually also tied to public school vouchers, which is obviously part and parcel of the reason why it ended up getting defeated. But again, a defeat is a defeat, regardless of the reasons why. And so Kentucky remains having one on the books, but not an actual charter school in operation. Montana, again, there was an injunction that was issued right after the passage of their charter school law, which happened in the summer of 2022, and it partially blocked the new charter school law, or what's called community choice schools in Montana. The court essentially said that the charter schools themselves are not necessarily unconstitutional, but again, it was the commission, the statewide commission, that was going to be overseeing all these charter schools, and that could be unconstitutional. And it could, kind of bump up against what their state board of education, their authority. So again, tons of more litigation. Their essentially legislator ended up amending their law, and changing the structure, and essentially prohibits the Montana Office of Public Instruction, which is their version of their PDE, from being involved in the approval process at all, and allowed for the Community School Choice Commission to move forward. Again, now we've had an approval. There's an additional layer of that approval process, which then requires their Board of Education to also approve them. And now there are 19 charter schools that have been approved and are moving forward to either already being opened or in the process of opening in the state of Montana. Keep an eye on Oklahoma. So this has been something, again, that's been percolating for some time. Oklahoma had an attorney general that had issued an advisory opinion right before his departure from office that essentially concluded that Oklahoma charter schools, in the charter school law that prohibited religious affiliation and non-sectarian curriculum, actually was a violation of the Constitution in light of the rulings that the U.S. Supreme Court had made in a Maine case, and also with the for lack of a better term, the gay cake maker case. And so the Diocese of Tulsa actually submitted a charter application for a virtual charter school. to the Oklahoma Commission that actually was approved on June 5th of 2023. Again, the National Alliance of Public Charter Schools is on the opposite side of this one, and in saying that essentially it's fundamentally unconstitutional for a religious entity to be running a public school. The Oklahoma Supreme Court, after a ton of briefing and oral argument, essentially agreed that it was unconstitutional for a public school to have, a religious operator as well as a non-sectarian curriculum. There was an appeal for SCOTUS to take this up on what's called a writ of certiorari, which is, they can take that case or not take that case. And there was a briefing that attached to that. In what shocked many in the in the charter school world, at least at the legal level, they actually granted certification last Friday. And there is accelerated briefing that is occurring on that case. So it's going to be interesting to see what the treatment is going to be under this particular Supreme Court. So again, keep your eyes on SCOTUS and what they're going to do in Oklahoma. Illinois, we see litigation that surrounds something. There was a bill that was passed called the Charter School Union Neutrality Bill, which requires that in the renewal charters for any running charter school, has to include something called a union neutrality clause. It prohibits charter schools from expressing any position on the matter of unionizing. It requires that any bona fide labor organization must have school access to school premises at reasonable times and areas provided to them free of charge to talk about employees about their right of representation through a union, and also recognize union representation through the card check rather than a secret ballot election. So just, to side note on that, charter schools in many instances are not organized under their state union law, which is generally easier to unionize under, which is done through a card check. A card check process essentially requires a majority of the folks submitting a card. And if there is a majority of folks submitting a card, that means you have a union. That does not mean a majority of your teachers. It just means the majority of folks submitting an actual card. What charter schools essentially are really much more under the jurisdiction of the National Labor Relations Act, which means there has to be a secret ballot election, an actual election process, and that does have to be a majority of essentially the collective bargaining unit that would be formed, which makes it harder. I mean, generally, it's rare that an election ends up rejecting a union, but again, it's harder to unionize under the National Labor Relations Act. This would essentially take away that jurisdiction from a federal level, which again, I don't know that a state legislature is actually able to do. So there's been some litigation that's been filed on that. Again, that's a sharp departure from Illinois schools, charter schools were actually the first to file for jurisdiction under the National Labor Relations Board and won those rulings initially when unionization practices were starting all over the country, but particularly in Illinois. So, again, if you want to take a look at this case, it's called Chicago Mass Civics case, and it'll give you sort of the background for that. But again, it also would take away the federal law rights that the charter school employees have. It also takes away the free speech rights of the employer, and also, again, the employee's right to vote in this litigation. So, we're keeping an eye on that. This was just recently filed, I want to say, circa around the summertime. So again, this is something that we're keeping an eye on. California has an interesting case too, where their version of PSERS, if you will, which is called CalSTRS, is now challenging charter school management organizations' participation in their state retirement plans, and have just recently denied retirement benefits to an individual who had been employed at a charter school network and had paid into the pension system for years, due to concerns that somehow the CMO participation would jeopardize the state system's status under federal tax law. They decided that after the guy had been working at this charter school for over 25 years. And now they're saying that there's no evidence that he provided credible service for participation in this pension system. Again, there's a lawsuit, obviously, and that is being uh, uh, spearheaded by the California Association for Charter Schools. Again, remembering that in California, the charter management organization is the holder of the charter. The networks don't have each individual school with charters like we do here in Pennsylvania. The charter school network is the actual holder, which means they would be the public entity that holds the charter. So again, that's something that we're keeping an eye on. We've heard throughout the years that there were going to be challenges to pension systems and charter school participation in them. Again, we're keeping an eye on that. We do have the safety valve here of Pennsylvania that we actually can participate in the 403B program. That is not the case in some other states. So, it's going to be interesting to see what's going to happen in terms of those schools that just have PSERs, and if there's going to be any challenges for that. And then finally, a Maryland case. Again, it was a funding case before the State Board of Education, which actually had implications for the entire Maryland sector. And that is because they have something called the Maryland Blueprint, which was passed in because they could see what was happening to their neighbors to the north in Pennsylvania. So they completely changed their school funding formula altogether, which actually resulted in significant losses of revenue to charter schools in the last 2 years of implementation. The Frederick County Charter Schools, which has 4 operating charter schools, challenged that. Essentially the funds that were being provided to them and a significant reduction, and resulted in essentially the charter school funding formula being revamped and direction being given specifically to districts to be more transparent in how they come up with the numbers to ensure that they are including all of the revenue and not just some of the revenue that the schools are getting under Blueprint. Again, and also because charter schools essentially are not their own LEAs, they are part of the school system. So like the employees at the charter school are employees of the district, and the students essentially are students of the district. So much so like their special education services only come from the district. And there are instances where the districts essentially will say to the charter school, this is the funding that you're going to get, but now we're deducting all of these things from it because these are services that you are purchasing from us. The charter school law down there does require that there has to be some level of negotiation about that so that the charter school can decide whether to use the district services or go outside of it. And in most instances of recent vintage, there has been no negotiation, and now that has been essentially ordered. So Maryland charter sector is very happy about that particular ruling. So one for the good guys, and so we have to celebrate that one. I am just going to talk very, very briefly because I know we're bumping up, and if folks have questions, I want to be able to entertain them. I mean, obviously, if you've been paying attention this week, there were a number of executive orders that were floating around that could potentially be completely earth-shattering when it comes to public education. There was an order essentially that froze federal funding on Tuesday. Lots of confusion attached to that. Essentially the way it was postulated and how it was ended up enacted throughout the day was that federal funding was going to be shut off essentially at 5 p.m. It then took multiple department and agencies to put out memos as to what funding was actually going to be shut off. But during the day, the Head Start program system was completely shut down as of noon. Medicaid also shut down their system as well. The Department of Education released their statements in the afternoon that it would not affect, though that is not the language of the memo, it would not affect things like IDEA funding or the title fundings or things like that. USDA never actually issued any guidance whatsoever in terms of what was going to happen to the National School Lunch Program, but the original memo essentially said any pass-through funds were going to be affected, and essentially pretty much everything I just listed is a pass-through fund. It does PDE has made it very clear that that ruling would have applied to discretionary grants and that would have impacted the charter school planning grant. So, unfortunately for all of us, that was reversed later in the afternoon and essentially withdrawn by Wednesday. However, there are some executive orders that are floating around or as of Wednesday that also are concerning with regards to defunding schools that essentially teach or have affiliations with critical race theory or other, quote, divisive curricula, end quote. It has instructed the Department of Justice to issue, to prosecute individual teachers, should they engage in gender affirming language or gender affirming practices for students in the LGBTQTA communities. Um, uh, I'm trying to think, there's another one that's of concern. Essentially things along those vein that we hear are going to be issued. As of Wednesday evening, they were floating around Washington, but we have not seen the enactment of those yet. Just before the inauguration, there was an injunction that essentially halted nationally the implementation of the April 2024 proposed regulations that went into effect in August. So it rolled back Title IX to the 2020 revisions. And then as of Monday, which was the date of the inauguration, the Biden administration essentially withdrew all of the proposed regulations under Title IX. And again, so that means that they're all rolled back. Those Title IX protections included things like being able to um, investigate and discipline students for off-campus behavior, and meaning off campus, not that we were at the basketball game and something happened. It was, something that happened totally outside of the realm of the school could be investigated under Title IX at the school level. It also included protections, particularly for the LGBTQ community, particularly for transgender youth. And now those have been rolled back to the 2020 versions. So with that, I am going to close my presentation